I'm Britney James, and I help consumers understand, protect, and enforce their financial and credit rights. If there's any error on yours, we will fix it. For more info, click the link in our bio or comment section below to speak to one of our licensed attorneys for help. What if I told you there's a single letter, one you can write today, that legally forces debt collectors to stop calling you, stop sending threatening letters, and even pause a lawsuit against you? And most Americans have absolutely no idea this letter exists. Stick around because in the next few minutes, I'm going to walk you through exactly what this letter is, how it works, and how you can use it to take back control of your financial situation starting today. Welcome back. If you're new here, this channel is all about giving you real, actionable information to help you deal with serious debt problems. No sugarcoating, no fluff. Today we're diving deep into debt validation letters, also called debt verification letters, what they are, why they matter, and how they can be a game changer when you're dealing with aggressive debt collectors. Segment 1. The law protecting you. Let's start with the foundation. There is a federal law called the Fair Debt Collection Practices Act, the FDCPA, and it is one of the most powerful consumer protection laws on the books. This law sets the rules that debt collectors must follow when they're trying to collect money from you, and it includes some very specific requirements that work entirely in your favor. Here's the first thing you need to know. Under the FDCPA, within 5 days of their very first contact with you, whether that's a phone call or a letter, a debt collector is legally required to send you a written verification notice. A physical letter. Not an email, not a text. A letter. That notice must contain 5 specific pieces of information. First, the exact amount of the debt they're claiming you owe. Second, the name of the creditor they're collecting for. Third, a statement that unless you dispute the debt within 30 days of receiving that letter, the debt will be considered valid. Fourth, a statement that if you do dispute it in writing, they must send you verification of the debt, such as a copy of a judgment or account documentation. And fifth, if you request it, they must provide the name and address of the original creditor. Why does that fifth point matter so much? Because in the world of debt collection, most unpaid debts don't stay with the original lender forever. After around 180 days of non-payment, lenders typically charge off the debt, write it off their books, and then sell it, often for pennies on the dollar, to what are known as debt buyers, or junk debt buyers. These companies buy massive portfolios of old debt, and then hire collection agencies to chase people down for payment. By the time you hear from a collector, the debt may have changed hands multiple times. Knowing who the original creditor actually was is crucial information for you. Now here's where it gets really interesting, and this is the part that most people completely miss, even people who've been dealing with collectors for years. You don't just have to sit there and receive their letter, you have the right to fire back with one of your own. And when you do it correctly, it triggers legal protections that stop collectors in their tracks. Segment 2. Your letter, the validation request. Under the FDCPA, once you receive that initial verification notice from the collector, you have a 30-day window to send your own written dispute back to them. This is called a debt validation request, or a debt verification letter. And when you send it, the law requires all collection activity to immediately stop calls, letters, legal threats, everything, until they respond with proper verification of the debt. Let me repeat that because it's that important. All collection activity must legally halt the moment they receive your dispute, until they can prove the debt is valid and actually belongs to you. This is powerful for several reasons. Debt collection in America is a massive error-prone industry. Debt buyers frequently purchase spreadsheets of names and balances. They don't get full account histories, signed contracts, or itemized statements. They get data, and data has errors. In legal practice, attorneys who handle consumer debt defense regularly encounter cases where the wrong person is being sued entirely. Not even identity theft, just a simple case of mistaken identity or a data error in a spreadsheet. It happens far more often than you would think. The Consumer Financial Protection Bureau has documented this extensively, with enforcement actions and consent orders against collectors for exactly these kinds of mistakes. Errors in the amounts owed are also common: incorrect interest rates, fees added without authorization, or amounts that don't match the original agreement. And then there's the issue of the statute of limitations. Every state has a deadline, typically 3 to 6 years depending on the type of debt and where you live, after which a creditor can no longer successfully sue you to collect. Some collectors will send you letters on debts that are well past this deadline, hoping you'll make a small payment, because even a partial payment can legally restart the clock on an old debt and revive their ability to sue you. Sending a debt validation letter puts you in the driver's seat. It buys you time, forces transparency, and puts legal pressure on the collector to prove their case before they can proceed. If this is already hitting home for you, do me a favor right now. Drop a comment below telling me where you're at in your debt situation. And if you haven't subscribed yet, hit that button now. We cover topics like this regularly, and you don't want to miss what's coming next. Segment 3. How to actually do it. So how do you actually send one of these letters? There are a few critical rules. First, it must be in writing. A phone call does not count. The FDCPA requires a written dispute sent within that 30-day window. Verbal disputes have no legal standing under this law. Second, timing matters enormously. That 30-day clock starts from the date you receive their letter, not the date it was sent. Once that window closes, the collector is no longer obligated to verify the debt just because you asked. So the moment you get that initial notice, treat it like a ticking clock. Set a reminder on your phone. Do not let it sit on the kitchen counter and get buried under mail. Third, send it in a way you can prove. Certified mail with return receipt requested is the standard. This gives you documented proof of exactly when the letter was mailed and received. In any future dispute or legal proceeding, that paper trail is your best friend. What should the letter actually say? At a minimum, it should state clearly that you are disputing the debt and requesting verification. A stronger letter will ask for specific documentation, the original signed agreement between you and the original creditor, a complete account history showing how the balance was calculated, proof that the current collector legally owns or is authorized to collect the debt, and confirmation of the original creditor's name and address. The more specific and professional your letter, the harder it is for a collector to brush it off. And here's a bonus most people don't know. If the collector never sent you that initial required notice in the first place, or if they fail to respond to your validation request properly and continue collection activities anyway, they have violated the FDCPA. That violation gives you the right to sue them in federal court. Successful plaintiffs can recover actual damages, plus up to $1,000 in statutory damages per violation, plus attorney's fees. In some cases, the threat of an FDCPA lawsuit has resulted in a collector forgiving the debt entirely just to make the case go away. Segment 4. Why this matters in a lawsuit. One more critical point. If a debt collector eventually does sue you, one of the first questions their attorney will ask in court is whether you ever disputed the debt after receiving their verification notice. Judges and opposing attorneys pay attention to this. Consumers who sent a timely written dispute are in a much stronger position than those who didn't respond at all. It shows you took the process seriously and exercised your legal rights. It can affect settlement and, in some situations, whether the case even moves forward. Here's the bottom line. A debt validation letter is one of the most underused, most powerful tools available to someone dealing with debt collectors. It costs you nothing but a stamp and a few minutes of your time, and it can stop harassment, expose errors, buy you critical time, and put you on solid legal footing. Don't ignore that verification notice when it arrives. Respond to it. If you found this helpful, please give this video a thumbs up. It genuinely helps more people in this situation find this information. And subscribe if you haven't already. New videos go up regularly, and every one of them is designed to help you deal with debt the smart way. I'll see you in the next one. I'm Britney James, and I help consumers understand, protect, and enforce their financial and credit rights. If there's any error on yours, we will fix it. For more info, click the link in our bio or comment section below to speak to one of our licensed attorneys for help.